Thank you. Well, this is a wonderful time to be talking after everyone's had their moment of break, and I'm sure you're all focused. So, and I'm sorry that there will be people coming and going, but that's okay. The first thing I want to do is thank the Algonquins of Quebec, and particularly the First Nation of Kitigan-Zibi, for their hospitality in the Algonquin territory that we both have a lot to do with. The second thing I want to do is thank you for inviting me to participate in this process, this wonderful conference. It is a real honor. I'm engaged in a process right now that's leading to a treaty. So we're in the midst of what many of you have already done. And this is a rather unique process. I think you'll find it very interesting. It's extremely complicated. So just as a heads up, this is an indication of what's pending. Right now, there's 26 comprehensive claims that have been settled since 1973. 75 additional claims are currently at varying stages of negotiation, 53 in BC, 14 outside of BC, and 8 transboundary claims. In BC, there are some Treaty 8 adherents, but there are some others that are particularly involved, 45 in Alberta under 3 treaties, and 166 of those 203 bands in BC have less than 500 people living on reserve. I'm only mentioning this in the context of what you'll see when we talk about the Algonquin situation, and some of these treaties are very applicable and some may not be. Right now, there are areas of Canada that have never had treaties, and particularly this one. The Algonquins in Quebec and Ontario have never signed a treaty. In point of fact, what you are sitting on is unceded Algonquin land, as is the nation's capital, the Parliament buildings, the Supreme Court of Canada. All of them sit on unceded Algonquin land. And this is a particularly important part of the world to the Algonquins because it's the confluence of the 3 rivers, and the Algonquins were river people. So you can imagine that this is a very important place in the Algonquin world. There are also the Mi'kmaq, and who knows more in the Maritimes. Those people have not signed treaties. They signed agreements of friendship, as Professor Jim had said earlier, Professor Miller had talked about, but they've never signed treaties. So who are the Algonquins of Ontario? Well, they've lived in present-day Ontario and in Quebec for thousands of years before the Europeans arrived. Today in Ontario, the Algonquins are comprised of 10 communities, the names of which I've described in the slide there. I won't go through them all, including the Algonquins of Pikwakanagan First Nation, who are situated in Golden Lake. The area of the Algonquins extends from Mattawa south to approximately Ottawa, east from the Ottawa River, and west to Kingston. This is the Algonquins of Ontario portion of that territory. There are currently 7,800 Algonquin voters. Now, the voters are not yet beneficiaries. What we have done is we've incrementally developed a negotiation criteria for people who would be of Algonquin participation in this treaty. We have Algonquin status people and we have Algonquin non-status people. The non-status people are those that have to pass through, at least as they stand today as voters, a rigorous test. They simply cannot be claiming they are Algonquin, sign a card and call it a day. Firstly, they have to demonstrate that they are direct descendants from a group of Algonquins who were involved in the signing of petitions as early as 1772. And we know who these people are. We have a very clear genealogical history. We have a very well regarded and highly trained genealogist and her staff who are involved in this process. So the first step is for a person to show genealogical descendancy. Second step is they have to show that they were involved in a life event in the territory within the last 80 to 100 years. It's a preliminary step. We still haven't figured that that is not the final criteria, but it's a step. The third step is they have to demonstrate that they have a social or cultural connection to a community, one of the 10 communities that have been identified. And finally, they have to declare their Algonquinness. Once they make that declaration, it's not something they can just resile from. And at the end of all of that, we've had a protest process where people can be protested, either the Algonquin ancestor that they claim descendancy from, or any of the links that they claim to have a relationship with the Algonquin communities they're involved in. We've had such protests. We, in fact, went to the former senior regional judge, Jim Chadwick, over a period of time, about 4 years ago when we were doing our last round of enrollment, and over 1,000 people were denied participation in this process based upon decisions that were made by Justice Chadwick and the Algonquin elders who were participating in the process. So this is not just a simple game where we're going through and saying you may very well be an Algonquin and we'll figure it out later. We're actually trying to establish a rigorous process. Of course, the Algonquins of Pikwakanagan and other status people who are members of that First Nation are directly involved as a start. The next slide relates to this particular negotiation. Now, as Professor Miller pointed out, the beginning for us is the Royal Proclamation. It really does establish the governance of this territory by the European power that claimed dominion and control over it after the Treaty of Paris, when the British finally concluded their latest round of battles with the French. Plains of Abraham, Quebec, all of that relates to this. And of course, at that time, the King of England proclaimed that no one was to deal with the lands in relation to native people who inhabited them without going through the steps that Professor Miller mentioned, which means that ultimately they had to do agreements with the government in a properly managed process to solve those treaties. Algonquin petitions for their territory go back to 1772, literally. Petitions were made by Algonquin people as a nation, groups of elders and headmen and chiefs were making petitions as a group, defining their territory clearly as the territory stemming from the headwaters leading into the headlands leading into the Ottawa River. Those petitions continued right through till 1983, the last one having been filed by the Pikwakanagan First Nation. Over 200 years elapsed. Why did that happen? Well, firstly, the Algonquins had fought for the French. Not a good thing in the war leading up to the Treaty of Paris. So they weren't exactly persons of allied consideration. But then, after about 2 wars, the American War of Independence and the War of 1812, the Algonquins distinguished themselves as fighters for the British cause. And at that point, the British started looking at them and saying, we better deal with this situation because they are our allies. Unfortunately, each time a petition would arrive in what was then York, in Upper Canada, the governor would take notice. In fact, some work was done to establish possible reserves with boundaries being marked out. But every time a governor got to the point of almost doing something, they would get replaced. And another governor would appear, and all of a sudden it would start again. The petition would arrive. It's not like there were faxes or emails or texts. These took months and months to get together and finally get some action on. And of course, here we are, 200 and some odd years later, trying to solve a problem that was supposed to be resolved back in the 19th century. And it's not an easy task. The government's negotiations began when Ontario in 1991 accepted the claim for negotiation, and in 1992 Canada joined. The negotiations continued until about 2001, at which time they broke down. I was not involved in that process. I got involved in 2003 when they asked me to see if I could bring it back into a state of operation. We managed to get the 10 communities to sign a protocol. We got them operational by 2005. We signed a statement of shared objectives with the governments in 2006. We started signing some agreements that dealt with the appropriate protocols that we would follow for the negotiations, and we got things underway. This is the Algonquin territory, and as you can see, it's a nice clean map. It reflects the headlands of the waters that drain into the Ottawa River, which is the line immediately to the right. Of course, there is a province of Quebec. At the time, of course, Algonquins knew nothing of provinces or Upper Canada or Lower Canada. Their territory extended both across the border of Ontario and Quebec and into Quebec. The Ontario Algonquins are trying to put together a treaty, but they fully realize and respect the rights and participation ultimately of the Quebec Algonquins, and we hope that someday that will happen. What you see there is a clean slate. That area was harvested by the Algonquins. It was bountiful. It was full of game. It was a beautiful place in terms of harvesting for furs, for meat, for any fowl, for fish. It was a particularly vibrant harvesting area. Here it is today. This gives you a sense of the magnitude of the development and things that have happened in this territory over this time. What you have in this area now, after 200 and some odd years, is you have 1.1 million people living here. You have hundreds of thousands of people coming up to recreate in cottages and the aptly named Algonquin Park. You have over 80 municipalities participating in this region with a number of townships related to those municipalities. You have scores of associations, whether they be cottage associations, snowmobile associations, forestry associations, industry, aggregate pit owners, hunt camp operators, you name it, they're here, and they're in this territory. And they're operating to some extent on Crown land. And then you have a whole pile of third-party interests, of course, that relate to those very associations I talked to you about. So what you have is 9 million acres. By the time we finally get around to talking about doing a treaty, 6 million of those acres have been put into fee simple. In other words, people are living on them. There's land that are being held by the Europeans that eventually came here and settled in the area. So what you see in that diagram is the essential erosion of that pristine place that was there to one that is now completely dominated by the European incursion, which, if you were really being mean and trying to suggest that this is the way there is an ethnic cleansing that occurred. The Algonquins economically were literally forced out of their territory by the forestry interests, the United Empire Loyalists, the disbanding of the regiments, the numbers and numbers of people who came from Europe to populate this area. So by the time you get to this point, we're trying to settle a problem that could have been dealt with much easier a long time ago, but this is what we're dealing with, and this is where we are today, so we have to solve the problem. That previous map, as I said, is the townships. Those are all the townships that exist, and you can see that lovely green area, which is the Algonquin Park, right stop in the middle. Of that 9 million acres, by the way, there's 6 million, as I say, that are in freehold. There's 2 million of those acres are park, including Algonquin Park. So we were left at the time we tried to start the negotiations to find land to satisfy our needs with less than 1 million acres of the 9 million that were there that have been picked over by people for 250 years. So you can imagine the challenges that are facing us as we try to put together a treaty with these types of limitations. So what we worked on for about 6 years was an agreement in principle. And we got to the point in 2012 where we did something rather unique, I think. I've heard that it might have been done elsewhere, but not to this level, not to this magnitude. We actually put the draft agreement of principle that we had created out for public review. Not just by our own people, which we went to first, of course, but by the larger public in which we are working with trying to solve this problem. Which brings us back to the concept of reconciliation. Some might think of this situation that has evolved where 250 years have gone by and we have been deprived of the opportunity to engage in a treaty as something justifying anger. And sure, it should. But here we are, 250 years later, trying to solve a problem with the people that are living here on this land today. And in doing that, it is an exercise in reconciliation. So we felt it appropriate to provide those that are there, the people that we will share this land with, an opportunity to see what we have come up with by way of a draft agreement in principle. And it was circulated, and people came in, and there were public meetings held throughout the territory, including Toronto, because a lot of the cottagers come up from Toronto. And we sat down with a whole pile of people, many of whom were angry, talked to them, explained to them our position, enlightened a lot of them, some not. And at the end of that, we modified to some extent the agreement in principle to reflect some of the concerns that had been expressed by some of the people that we were ultimately going to share our land with. That ultimately resulted in an agreement in principle, which we finally signed in 2016 after a ratification vote was done, over which 90% of the Algonquin population expressed their desire to move forward. It's only an agreement in principle, it's non-binding, and there are some issues in relation to self-government, and particularly for Pequawtnagon, that we still have to address. And the negotiations are ongoing, so what you see in the treaty or in the agreement in principle is by no means the final chapter of the treaty. The key elements of the agreement in principle. Over $300 million is to be transferred to the Algonquins, assuming that this treaty gets finalized. That amount has an inflationary clause that means today it's worth $475 million or more. It will be put into a tax-free account, assuming we complete the deal, and it will not be taxable. Any of the income or capital arising out of that trust will not be taxable. Only will be taxable when it gets used outside of the trust. So when we start spending the money and using it, and then it develops income, that's a different story. But while it's growing, we will have it. That is by no means the end of the negotiation. So people don't walk out of this room assuming that this is the final number. This is the beginning of a discussion. And we got to this point and we devised some of the elements of what that number will look like when it's finished and how it will be managed. Not less than 117,500 acres will be transferred out of the almost 1 million that's left of the treaty area. That land will be held in fee simple. However, 65,000 acres of that land will be non-taxable, no realty taxes. Those will be nation lands, and in those nation lands we will do as we feel appropriate to protect the Algonquin way. Once again, don't let that number be your final guide, because there are still ongoing negotiations. The other elements of the treaty involve things like the harvesting chapter, which when you read it, and I encourage you, there is a site at the end of this paper which you can find when you get the copy of it later. There's a website called Tanakawin, and in there is the draft and final agreement in principle. And you'll see a chapter on harvesting. I encourage you to read it, because I believe that we have managed to devise a chapter that actually takes us beyond the sparrow decision in terms of the protection of the harvesting rights of our people. There's also a Parks and Protected Areas chapter. You will see that the Algonquins will be undertaking the co-management of a number of parks, including Algonquin Park. That will be at the conclusion of this, but we're already starting pilot projects with respect to the management of some of those parks. There's a chapter on forestry in which we will be engaging with the forestry interests, particularly on our lands. There will be a transition from some of the SFLs that are presently on those lands, and we will be engaging with the industry, as we already have, in co-managing some of those processes and taking the benefits of them. And of course, there will be an eligibility enrollment chapter, which I'll talk more about in a second, because we're moving further and further down the road on that. So now that the AIP has been signed, we have been fully engaged in trying to move it to the next step from 2016. We've devised what's called a Gantt chart in engineering terms, where there's over 250 items of further negotiation that have to be done, ranging from things like negotiating with hunt camp operators in relation to their hunt camps on our property, whether it be with forestry holders, all of those interests, the cottages, the snowmobile trail people, all of those interests that have anything to do with our land, we have to negotiate and come to conclusions with. And again, you'd think that's an overwhelming task. It isn't. What it really is an opportunity to interact with the people that will ultimately be our neighbors. And when they talk about reconciliation, this is an example of the very thing that it embodies. Not only are we negotiating and trying to reconcile with the governments, but we're negotiating and reconciling with the people who have come on our land, not necessarily in a way that we find appropriate, but here we are in 2017 with a reality that we have to come to a conclusion on, and in doing that, we're going to negotiate with the very people that we will be neighbors with for the rest of whatever time is left. We are still involved in public outreaches. For instance, recently there was an EER, it's an environmental process, which will allow us to cut through the transfer of the lands when we finally conclude the deal. But again, it became another opportunity for public meetings where the government was taking people through the environmental studies that are being done in relation to any of the lands that we receive to ensure that none of them have any pollution elements attached to them. So we get through that process, then we are going to, what we're trying to do this year is complete our enrollment criteria, have that inserted into what we will call an interim constitution, because right now we're living within a process in which we have a structure, a political structure, but it's not a fully endorsed political structure by our beneficiaries, whom by then we will hopefully have. And we're going to complete that with an interim constitution, which we would like to have done by the end of next year, which will give us the basis for our governance, which will allow us to then engage in the management of our trusts. We are already taking on assets, so we have to have a basis for managing them. It'll allow us to have a political structure rather than just a negotiation structure, and will lead us into the next phase, which will be the finalization of the treaty, and in doing so, full and complete partnership with the governments with whom we are dealing. Assuming we can get through that process, we will then have a ratification vote on the final agreement, which is still in negotiation. That will be approved, and then there will be legislation to implement the treaty. Consultation. Well, I'm not going to finish this. We have very little time, but I'm going to talk about this in particular. This is a rather interesting situation. Out of the discussions that we had, you can see, as was discussed by Jim and Jim, there are consultations that necessarily arise when you have Aboriginal rights in a particular area or title. In this particular case, we're talking about an area of 9 million acres in which there are, as I said, 80+ municipalities. Every day, something is happening in relation to Crown land. So over the past number of years, we have had over 2,500 consultations that we've had to process since 2006. 300 new consultations since January of 2007, and over 500 projects are currently active. What does this lead to? Well, you can see this lists some of the very, very important pieces of the puzzle that are evolving as we're doing the treaty. For instance, we have engaged with Rockcliffe, with the Canada Lands Company, arising from the disposition of a military base called Rockcliffe in the city of Ottawa. We co-ventured with a developer and Canada Lands Company to participate in the development of that project. We also engaged with the City of Ottawa in the development of the Pimsey Station, which is one of the stations on the new light rail transit project that is being provided financing by the federal government in Ottawa, in which the entire station will be dedicated to Aboriginal art and themes. And again, Kitigan Zibi has had a real role, and some of their artists are going to be demonstrating there. Finally, in Ottawa, you start seeing the reality that this was an Algonquin nation area. How many times have you been in this city where you've seen, or in Ottawa, where you've seen nothing but European statues? There's nothing to celebrate the presence of the Algonquins and the Aboriginal people that were here. This is what we're trying to do. We're engaged in another project in 401 Le Breton, which is another property where there's going to be a couple of apartment dwellings developed, which we've again negotiated with Canada Lands Company. We have a joint venture agreement. What I'm showing you is the opportunities that are arising by virtue of the rights of consultation that flow from our engagement in the treaty negotiations and the assertion of those rights in this process. Finally, reconciliation. Okay. I've taken a few quotes. I think they're really important. Canada is a project on reconciliation, so said Chief Justice McLachlin. And what we have here in our Supreme Court is comparable for Aboriginal rights to what the Marshall Court was for civil rights in the United States. The court here has been that progressive and that life-changing. And that's, I think, a very strong statement. What is reconciliation? It's the restoration of friendly relations. Restoration of friendly relations. So when Mr. Eford talks about it in his report, the answer lies not in the nebulous concept of relation building. In other words, it is imperative that governments and Aboriginal communities heed the repeated admonitions from our court to make reciprocal, good faith efforts to reconcile their differences. The quote I next follow is, "Litigation is the death knell of relationship building." Now, it's necessary sometimes because you have no alternative, but judicial proceedings are a blunt instrument that tends to expose divisions between parties and deepen hostilities. This is coming from a litigation lawyer. I love litigation. I do it well. But I can tell you right now that the best way of solving these problems is to engage in a negotiation with respect. Respect. That's the critical piece. Respect. So in my final point, my comment, the challenge to First Nations is to put the past pain and grievances and the distrust behind them and be willing to work directly as equals with the governments toward a fair and just solution that is built on compromise, not capitulation, and that is driven by good faith actions by those governments in accordance with the honor of the Crown. What we're doing with the Algonquins is hopefully a panorama and hopefully a realization of that principle. And I thank you for your time.